thank you all very much for attending today. It is the final seminar of the three-part conflict of laws series that I have been running this year. This one follows on from the first and second seminar of the three-part series. The first one which dealt with jurisdiction, second one which dealt with the applicable law, and today we'll be considering the final step and the ability of a foreign court to recognise and enforce an English judgment that in some way, shape or form deals with property that is located in another country. Compared to the last two seminars, this one is slightly shorter, and there's a reason for that. In that there are no set principles at play in considering whether or not an English judgment can be recognised and enforced abroad. When I say principles, I'm talking about English law principles, and you'll see why when we come to the relevant point. The headliner point really from the outset is that practitioners will have to conduct some form of homework in determining the question of whether or not English judgment can be recognised and enforced in foreign jurisdictions when there is property that is located abroad, following the transition period ending in respect of Brexit. So before we go on, and the common theme that's run throughout these seminars is why are we talking about this topic? Well, if you are practicing real property, there's a real chance that you will be dealing with property that's located abroad in situations, for example, where there is a contract prepared to have been entered into in this country. You may also deal with clients in this country where judgment has been obtained regarding property located abroad, and the question is, well, what can we do with that? And whilst it is a slightly niche topic, these issues do crop up now and then, and it has never been easy to decipher the rules and procedure in the law. And so the aim of these seminars has really been to provide a starting point and a roadmap for practitioners in determining how one goes about determining jurisdiction, applicable law, and enforcement and recognition. I am considering the position post-Brexit after the end of the UK-EU transition period on 31st of December 2020, and the position that applies outside of the United Kingdom altogether. There are certain rules that apply between England, Scotland, Northern Ireland, but that's not been the purpose of these seminars. The purpose has really been to look at the perspective more globally outside of the United Kingdom altogether. And when we're talking about conflict of laws, we are really talking about any case where there is a foreign element involved. So whether that's the law that applies to a contract, for example, or for the purpose of these seminars, the subject matter of the dispute is located in a foreign country. Here, the property or the rights in respect of that property. The last two seminars, we considered one, how the court determines jurisdiction to hear a case in the first place. And then secondly, how the court goes about determining that the law that applies to the substantive dispute in question. Today, we're looking at the position post-judgment, where you have an English judgment that deals with property that's located abroad, but the question becomes how can you enforce it and how can you get a foreign country to recognize it in the first place? What I intend to do firstly is to provide a recap of jurisdiction and applicable law, because effectively one can't look at the question of recognition enforcement in an isolated fashion. And I do recall that my previous seminar was about a month and a half ago, so it will provide a good a recap of the position that occurred before, the position that I provided seminars on before. Then I'll consider what is meant by what the definition is for recognition and enforcement. Then the question of recognition enforcement when dealing with English judgments, dealing with property located abroad, then provide practical tips. And for all your benefit, I produce an overview mind map, which I can email across to you at the end of this seminar, that provides summary of all three seminars together. So some of you will remember from last time that generally when speaking about jurisdiction, that refers to the court's ability to hear the case in the first place. So we're not looking at the substantive dispute in question, but it is the first hurdle that a claimant would have to overcome. The question is ordinarily dealt with by way of the service provisions in the CPR. So unless a defendant submits to the jurisdiction voluntarily, which the procedure for that is set out within Part 11 of the CPR, then the defendant has to be properly and effectively served with the proceedings in line with the requirements of Part 6 in order to engage the court's jurisdiction. In other words, by way of effective service, the defendant has submitted to the jurisdiction. Of course, that's very straightforward in the case where the defendant is located in this country. where the usual CPR 6 rules would apply. But if a defendant is located outside of England or outside of the United Kingdom, there would have to be an application for service out made and a permission hearing listed to determine whether or not the defendant can and should be served abroad. And you'll recall that the test for that is again within CPR Part 6, or partly within CPR Part 6 in dealing with service out. And the English courts will assume jurisdiction where the four-part test, which you may recall from my previous seminars, has been satisfied. So you need to show, firstly, a good arguable case that the claim falls within one of the gateways set out within the CPR Practice Direction 6B. There's a serious issue to be tried on the merits, so you do look at the substantive merits of the case to a degree. Then one looks at whether or not England is the proper forum for hearing of the case, the concept of forum conveniens. And then the court exercises an ultimate discretion in order to determine whether or not the defendant should be, whether the claimant should serve proceedings out to a defendant located abroad. But when considering property, there is an additional layer to consider, as set out on screen. The third bullet point, the court has no jurisdiction to entertain proceedings for the determination of the title to or the right to possession of immovable property situated outside England. You recall that this comes from a case of Mozambique, and it's an exclusionary rule in respect to property located abroad. But the question is whether or not that exclusion rule applies is determined by whether or not the principal question in the proceedings is the determination of the title to or the right to possession of immovable property, where the proceedings actually deal with numerous equally important aspects of the case, in addition to the determination of the title to or the rights to possession, then the exclusion rule would not apply. So the question is whether or not there are other questions which are merely incidental to titles and rights to possession, or the case or the outcome of the case it depends wholly on the question of title to rights to possession, in which case the exclusion rule would kick in. You'll also recall that there are certain exceptions that apply in respect of contracts, equitable claims, for example, so some form of personal obligation which will be unconscionable not to enforce. So whether there's an action in fraud, fiduciary obligations, contract, unjust enrichment, for example, to recover sums of money paid under a contract for sale of land. That's one example. You also have tort and trespass, where the principal question is not the determination of title to or rights to possession of property. And then the administration of trusts and estates, where the property is located abroad, but there's also to be administered within the estate, property that's located in this country, where it would make sense for an English judge to just simply deal with the property, deal with all of that property within the estate as a whole. We then considered at the last seminar the question of applicable law. So once the court has determined jurisdiction, the next question becomes, well, what law applies to the substantive underlying dispute in question? And we look specifically at contracts regarding immovable property, i.e. real estate. And the law that's applied is the UK Rome 1 regulation. So that's the Rome 1 regulation that applied post-Brexit. And one needs to determine whether or not you fall within scope, which is set out within Article 1. Whether or not there's been an express or implied choice of law in that contract, that's Article 3. And the most usual or likely scenario where there's what the position is, where there's no choice that's set out within the contract at all. The position in the absence of choice, and that's set out in Article 4. And there's been a common theme running throughout these seminars of taking it all step at a time. So going through those various articles one at a time in order to determine the question of what law applies to the dispute. And you recall, in respect of contracts related to property, Article 4 says that a contract relating to a right in rem in immovable property shall be governed by the law of the country where the property is situated. So it's a very similar position regarding applicable law as it is in respect of jurisdiction in the first instance. But there is an escape clause that we discussed in quite some length last time, that where it is clear from all the circumstances of the case that the contract is manifestly more closely connected with the country other than that indicated in the previous paragraphs of Article 4, the law of that other country shall apply. So the example there is you could have a property that's located abroad, but all the other connecting factors, the parties to the proceedings, the contract, all points in the direction of direction of England. Then there is an argument to be made that English law should apply to the dispute because it is manifestly more closely connected to England. You'll also recall that if the contract relates to rights in rem, so here, if for example, we're dealing directly with the conveyance of land or the transfer of an interest in land, then for obvious reasons, it's the location of where the property is seated, i.e. the lex situs it's called, that determines what the applicable law is. So if a property, for example, is located in India and you're dealing directly with its conveyance or transfer, then obviously the law that applies in India would apply to that conveyance and transfer. But the underlying contract for sale, if entered into in this country, the argument is that English law should apply so long as the connecting factors point manifestly more directly with England. We then considered the importance of pleading foreign law as a fact when relying upon the same, the importance of utilizing specialist expert reports from foreign lawyers and judges by way of a Part 35 expert report when proving foreign law, and the strategy to employ in that respect, and whether or not the default rule that foreign law is not to apply where it's not pleaded, or that where that English law would apply where foreign law has not been proved, but it's presumed to be similar to English law. We discussed at some length whether or not the default rule, that presumption of similarity, should apply or should not apply, or whether or not it should be relied upon in the first place. That really depends on the case in question, client instructions, and the tactics you want to employ. But on the whole, it's quite an unknown territory, a bit of a stab in the dark to rely upon those default rules and presumptions, particularly when you know that foreign law is to apply. So once we've determined jurisdiction, determined that English law is to apply, for example, the question then becomes, well, you've obtained your judgment in respect of, for example, a contract for the sale of land, involves property located abroad. It may even involve a refund of a deposit, for example. The question becomes, how do you have that recognized in a foreign jurisdiction so that it's enforceable against a defendant that may be located in that country, for example, or the property may be located in that country? Well, firstly, what do we mean by recognition and enforcement? Well, recognition of a foreign judgment is simply a common sense reference of a court's recognition of it. So, for example, a party seeking to rely on it to plead res judicata may have that foreign court have that judgment recognized in order to utilize that defense. So it's a possible defense mechanism, as it can be seen as a shield as set out on the screen on the picture. Enforcement is a positive step to give effect to that judgment. So we're all aware of the methods of enforcement that apply in this country, for example, charging orders, attachment of earnings orders, writs and warrants of possession and control. It's a form of attack to give effect to a judgment. But you must remember that a judgment always requires recognition before it can be enforced in a foreign jurisdiction. And that there is no special procedure, for reasons which I'll come on to shortly. One cannot lay down specific principles when considering recognition and enforcement of English judgments related to property located abroad. It's really a case-by-case analysis. So when discussing recognition and enforcement of English judgments related to property located abroad, the discussion here is really about proceedings that have commenced after 31st of December 2020, because prior to the end of the transition period, a combination of rules applied by way of the recast Brussels regulations, the 2001 Brussels regulation, and the 2007 Lugano Convention, which determined the position on recognition and enforcement in relation to proceedings that had commenced before then. But this is not the case anymore. Following the end of the transition period, those particular regulations and conventions do not apply. The unfortunate reality really is that the general position is that whether or not an English judgment can be recognized and enforced depends on the conflict of laws rules or private international law rules that apply, particularly in the country that you're seeking recognition and enforcement, which would unfortunately mean that you would have to obtain the advice, or ideally obtain the advice, from lawyers located in that jurisdiction in order to be sure about what those principles are, again, to increase the likelihood of success in having that judgment recognized and enforced in a foreign jurisdiction. So there is obviously an inherent uncertainty behind recognition enforcement that a client would need to be aware of. And of course, there is an unfortunate likely expense, because as a practitioner, you would have to conduct that homework and also get the advice from that local lawyer. But taking a step back, where can we look for these particular rules in the first place? Well, firstly, there are certain reciprocal arrangements between England and other foreign nations, particularly the Commonwealth, that it's worth looking into. There are certain bilateral treaties, for example, between countries such as England with India, Australia, and Canada. And those bilateral treaties set out the position in respect of recognition and enforcement. Such treaties, generally speaking, require declarations of enforceability of the foreign judgment from the court where enforcement is sought. So you don't have to start an entirely new action. There wasn't much on this, actually, and practical law, it was the starting point in order to find out about what these bilateral treaties say. In effect, they apply, generally speaking, to money judgments. So it's unlikely to be helpful where you are dealing with an enforcement mechanism regarding property abroad, for example, tort or trespass, or for example, injunctions. Further, you'd need to show jurisdiction, generally speaking, of the original court on a territorial or consensual basis. So if you've served abroad on a defendant, you don't fall within the mechanism of service territorially, i.e. within the jurisdiction, and nor has the defendant consented to submitting to jurisdiction. And therefore, there may be difficulty in getting through the door on a reciprocal arrangements basis, albeit my advice would be to check out those details depending on which country you're looking to seek recognition enforcement, to determine its scope, in order to determine whether or not those reciprocal arrangements are still in force, the defenses that a defendant may raise, the procedure, because each one is likely to be different. More likely than not, you're probably going to get through the door by looking at what the national law of the country in question is. So where no particular regime applies, enforcement is a matter of national law in the enforcing state as to which local advice must again be sought. You have to be very specific here, because certain countries, as you'll be aware, have certain states and local laws within that state. So you have to be very precise in your research, and also make sure that you have approached the correct local lawyer, that the correct law has been looked into in order to determine the question of recognition and enforcement in that particular country or within the state of that country. However, a good starting point to set out at the bottom of the screen is the Multilateral Memorandum on the Enforcement of Commercial Judgments for Money, a document that was provided and created by the Standing International Forum of Commercial Courts. I had a quick look at that, and within it there is a good summary of the law that applies behind recognition and enforcement for various different types of countries. And whilst on the whole it's talking about commercial judgments for money, in actual fact, it does talk about immovable property and property rights as well. So I would urge practitioners to look into that particular document as a starting point for research. One particular point to note, on reciprocal arrangements, there is within the White Book CPR 74 that deals with enforcement in foreign countries of judgments of the High Court and the County Court in this country, and particularly Rule 74.12 and 13. In essence, those rules provide a requirement for a certified copy of the judgment to be provided to the enforcing court. And that's something that has to be provided by the High Court and the County Court in this country. You would need to make a Part 23 application without notice, supported by written evidence that exhibits the claim form, evidence that had been served on the defendant, statements of case, the funding arrangements of your client, and written evidence identifying grounds on which the judgment was obtained. whether or not the defendant objected to the jurisdiction and their grounds for objection, whether or not the judgment was served in accordance with Part 6 of the CPR, and whether or not the judgment is subject to a stay of execution or an application for a stay. Also, whether or not that judgment has been appealed, whether the time for appeal is expired, whether an appeal notice has been filed, the status of any application for permission to appeal, and whether an appeal is pending. And actually, some of the commentary also talks about a default judgment, which is similarly can be similarly recognized and enforced in a foreign jurisdiction. But in the evidence, you'll also have to show whether or not there's a set-aside pending, or whether or not an application for set-aside has been made. You'd also need to set out whether the judgment provides for payment of the sums of money and certain details in respect of interest. It's worth looking into CPR 74.12 and 13 in combination with PD 74A, which provides various details about that application and what a certified copy of a judgment would look like. You'd apply to a High Court master if it's in respect of a High Court judgment. But if you are in a district, if that judgment is one that was entered in the district registry, then you can get a district judge within that district registry to exercise the powers of a master to obtain that certified copy of a judgment. But as I say, this applies where a reciprocal arrangement is in place and that reciprocal arrangement is enforced and does apply to your case in question. You'll see from CPR 74.12, three particular acts are referred to on sections within that act. So it's the Administration of Justice Act 1920, the Foreign Judgments Reciprocal Enforcement Act 1933, and the Civil Jurisdiction Judgments Act 1982. And each of the provisions that are mentioned within 74.12 makes very clear that it's a reference to reciprocal arrangements that are in place between England and that foreign country. So CPR 74 will only apply, or those particular provisions of CPR 74 will only apply where those reciprocal arrangements are in place. So then we come on to, well, the law behind recognition enforcement is quite vague, and it's something I had to accept when conducting my research. There's not much on this following Brexit, which is quite unhelpful for the practitioner. But it tells you the importance of conducting your research, because ultimately it all depends on what that foreign country where you're looking to recognize and enforce that judgment, what the law there is. So the first question really is it proportionate or cost effective to pursue enforcement and recognition abroad? It is a bit of a stab in the dark. But if you've reached the point of judgment in the case involving a foreign element or property located abroad and you've succeeded, you may be left with no option but trying to enforce abroad, because ultimately you wouldn't have got to this stage unless you had succeeded, unless that property was located abroad, unless there was a way in which you can recognize and have that judgment enforced in that foreign jurisdiction. It won't be an easy line to draw in order to stay proportionate and cost effective in your approach. So firstly, homework would need to be done to ascertain the rules relating to enforcement and recognition. What forms of methods of execution are available in that foreign jurisdiction? What defenses the defendant may have? The time it will take to enforce and execute in the first place. I would suggest that homework is done at an early stage in the proceedings, because obviously that will determine whether or not the dispute is taken further on board, whether or not proceedings are even issued, because ultimately it may not be worth it in the first instance. You'll also have to factor in an application to the court potentially for a certified copy of the judgment. Also factor in the need for foreign law advice. But if you are already obtaining expert evidence on the substantive dispute, it may be worth at the same time obtaining advice on enforcement and recognition. And as I said, there is general uncertainty following Brexit in terms of recognition and enforcement. A theme throughout these seminars has been the need to take everything a step at a time. So again, locate the relevant enforcement recognition law that applies, obtain clear-cut advice from a foreign lawyer, make your application for a certified copy of the judgment. Make sure as well when you're applying for a certified copy of the judgment, that the evidence is detailed. When I look at CPR 74, there is an extreme amount of detail that's required within these applications, and I sense the reason for that is the court in this country is rehearsing the likelihood of obtaining recognition and enforcement abroad, making sure that the relationship between this country and foreign nations is not disturbed by any attempts or weak attempts to have that judgment recognized and enforced abroad. And so essentially it looks at whether or not it's likely that judgment will be recognized and enforced abroad before a certified copy of that judgment is provided. And of course, if a certified copy of that judgment is provided to a foreign country, there'll be information which they ought not, in the usual sense, ought to be privy to. So again, it's important that detailed evidence is provided to persuade the court to provide you with that certified copy. Fourthly, when looking at recognition enforcement, it isn't an isolated topic for reasons already explained. As I'll show in a moment, it is important to consider recognition enforcement as early as possible, not to leave it right to the end. It should form the part of the starting analysis on jurisdiction and applicable law, because ultimately the strength of the case, the legal and evidential complexity of that case may help determine the viability for recognition and an attempt for recognition enforcement in a foreign country. It may be that it will not prove too problematic to enforce, but in some cases that may not be the case. So it's important to look at the case as a whole at an early stage of the proceedings, rather than saying, well, let's look at jurisdiction for now, put the proceedings through the door, and then applicable law, and then we'll see where we are up to when looking at recognition enforcement at the end. But in any event, there may be an advantage or a tactical advantage of simply obtaining a judgment and seeking for that judgment to be recognized, not necessarily enforced. For reasons of res judicata, you may have a defendant who tries to bring proceedings in a foreign country when the substantive dispute has already been determined here. So it might be worth simply having the judgment recognized so it sits in that foreign country, and it makes sure that a defendant does not take any unauthorized or unsubstantiated steps which may affect the judgment that's already been obtained. It also may force the hand of a defendant, not necessarily by way of forced attempts to enforce that judgment, but in essence to come together in order to make sure that that judgment is satisfied in some way. So I thought I'd produce a mind map to summarize the 3 seminars in a nutshell, and hopefully you can see it on screen, and I can email this across to you, and you'll have my email address on the final screen, so please feel free to just drop me an email, I'll forward this on to you. Just to provide a summary of how all of this comes together. So you'll see the first question really is there a foreign element involved? For our purposes, the property is located abroad, but the dispute is to be determined in this country in respect of it. So the first question is jurisdiction. Are we serving in? Has the defendant submitted to the jurisdiction? In which case, the first part of the question of jurisdiction has been satisfied. If the defendant is located abroad, we need to serve out. We need to show, is there a good arguable case that the claim falls within one of the gateways, particularly the gateway in respect to property or contract, whether or not there is a serious issue to be tried. A very similar test as applies for generally across the jurisdiction for injunctions. The question of foreign convenience. Is England the proper forum to bring the case? And you'll recall that the principles come from a case called Spiliada, and it looks at various different connecting factors as to why England may or may not be foreign convenience. And then the court exercises an ultimate discretion, which, if the first 3 limbs of the test are satisfied, is probably going to be in favor of a claimant to serve out. But outside of service, there is an additional gloss from Mozambique, as I discussed earlier. Does your case principally concern itself with questions of title or rights to possession of property? If it does, then you probably fall within the exclusion rule and you can't bring your claim in this country. If it's an equally important part of a case with other important elements as well, for example, it may involve a breach of contract claim for the recoupment of a deposit, for example, but the property is located in foreign territory, then you probably can get through the door and you're outside of that exclusionary rule. However, there are specific exceptions in any event in cases involving contract, equity, torts and trespass, and trust and estate, as I alluded to earlier. Then we come on to, well, we've got through the door on jurisdiction, on applicable law. You would apply the UK Rome 1 regulations when dealing with contracts in respect of immovable property or rights in rem in respect of immovable property. You need to question whether or not you fall within scope of those regulations, whether or not the contract sets out an express or implied choice of law as to what law is to apply to that contract, what the position is in the absence of choice. Usually, similarly to Mozambique, the law that applies is the law of the country where the property is located. And then, can you get your case through the escape clause if indeed you wouldn't ordinarily be able to apply the law of England to the dispute in question? So is the case manifestly more closely connected to England than it is to the foreign jurisdiction? And again, the biggest example is property is located abroad, but everything else points in the direction of England. But you must remember that the actual conveyance, the actual transfer, the actual rights in respect of that property are dealt with by the lexitas where that property is located. And from a practical perspective, you need to plead foreign law in your particulars of claim. You need to prove your foreign law by way of a CPR 35 expert report from a foreign lawyer or a judge. And you may want to steer clear of the default rule that English law applies where you haven't pleaded foreign law, or that English law is similar to the foreign law where you haven't proved it, because ultimately the outcome of the case becomes highly more uncertain if those default rules or presumptions are applied. It may be a tactical ploy to utilize English law to determine the dispute, but there's no guarantee that a judge would necessarily do that when common sense would apply and you'd think, well, this is a case involving foreign law. There's no guarantee that the judge will follow suit and simply say, well, I'll apply English law to the dispute in any event. Then we come on to enforcement recognition. Does a reciprocal arrangement apply? If it does, you'd apply CPR 74.12 and 13 to obtain a certified copy of the judgment to provide to the foreign court where the judgment is to be recognized and enforced. Again, there's detailed evidential requirements set out within CPR 74 that I would urge you to have a look at. And that particular document would have to be provided to the foreign jurisdiction, who will then provide for a declaration of enforceability. And you'll then be able to enforce that particular judgment abroad. But obviously that, again, all depends on what those reciprocal arrangements say, what methods of execution are available to you, and the cost of the same. If the reciprocal arrangements don't apply, then it's a simple matter of looking at what the national law of that country says about recognition enforcement. And it's important to obtain local law advice about what the position actually is on the ground. And again, post-Brexit, the position has become that much more uncertain. So the importance of obtaining advice from a foreign lawyer cannot be understated. And as I said, there's homework to be done for the practitioner to obtain that foreign law advice. There's unfortunately no way out of that following Brexit. The position before Brexit was that much more simpler because there were regulations and conventions in place, which would have provided a steer as to the ability to recognize and enforce a judgment abroad, particularly where the property is located abroad. So hopefully this mind map will provide you at least a starting point in your research and a steer towards a conclusion as to whether or not you bring proceedings in the first place, and if you do, whether or not the question of jurisdiction, applicable law, enforcement recognition has been satisfied. So thank you all very much for attending this final seminar. It was a much more shorter seminar, the reason being there isn't actually that much on this following Brexit, which came to a surprise for me as well. the position on Brexit, whilst it has simplified matters, has actually created that much more uncertainty as to question recognition and enforcement. But hopefully, I provided you with a simplistic overview of how the conflict of laws regime operates in the sphere of real estate litigation, particularly where a contract has been entered into in this country and the property is located abroad. And I hope that this aim has been achieved and you've been left with at least a little something that you can take and utilize in your practice. There is, as I say, my email address on screen for any questions that you may have. There's also the chat function at the top of the box, so feel free to drop me a question. I'll stay here for a couple of minutes longer. Otherwise, as I say, my email address is on screen. I can provide these slides to you if it will be of any assistance. And again, feel free to drop me any questions. So thank you.